So for the first and foremost, the topic that we would be discussing is more about the issue of shares. I'm sure you might have dealt it in your inter, but we will try to understand how things are different when we compare it with the inter with the final. Okay. Now, if you see what are the different types of issues that you know, issue of shares. When we talk about issue of shares, we know public company, private company. Now, what are the different types of issues? Yes, first one is public issue. Yes, then private placement. Yes, rights issue. ESOP, bonus, sweat equity, equity shares with differential voting right. Equity shares with differential voting right. So if you understand, these are the different types of issues that can be made by a company which intends to issue the shares to public or to the members of the company. Now when we compare with the public company with a private company, if you see, except this, here control C, we will have to, rest of things will be applicable here, except the public issue, all other things, that is, if you see a private company can do private placement, rights issue, bonus shares, ESOP, equity, and equity shares with differential voting rights. Now, if you try to understand the basic things, okay. Now, what do you mean by issue? Giving an offer to the shareholders or members or to the public based upon the criteria. So, if you see, first we would be issuing the shares or first we would be offering the shares. Then once we offer, the shareholders or the members may accept it or reject it. Based upon that, we accordingly what do? We conduct a board meeting and allot shares. Yes. Now let's go one by one. Let's try to understand what it is. Now, what do you mean by rights issue?
Shares to employees, further offering them with other shares.
Okay. Issuing shares to the issuing shares to the existing shareholders. Very much right. Issuing shares to the existing shareholders. Let's assume there is a company called as XYZ Constructions Private Limited. This company has got two shareholders, shareholder X, shareholder Y. Okay. Assume this guy is holding 5,000 shares. This guy is holding 5,000 shares. Okay. The ratio is what? 50%, 50%. Yes. So the total capital of the company is 10,000 shares of rupees 10 each. That is 1 lakh. Yes. So when I give an offer to the existing shareholders, that becomes a rights issue. Yes. Okay. We'll just park this for some time and try to understand the next concept. Now, what is private placement? Perfectly right, that if you understand, issuing the shares to a selected group of persons. When I say selected group of persons, now we know that there are provisions saying that it can be maximum 200 in a year. Now, let's assume I am selecting this, again, this example remains same for all the, entire class. Okay. The company is XYZ Construction Private Limited. There are two shareholders. Now, I am selecting two shareholders. Shareholder X and shareholder Y. Shareholder X, shareholder Y. In the first rights issue, what did we say? If I am issuing shares to X and Y, that becomes a rights issue. Now, what is the second one? Private placement. When I say private placement, I am selecting, what do you mean by private placement? Issue of shares to the selected group of persons is called as a private placement. Let's assume if I am selecting two shareholders, shareholder X, shareholder Y. Okay. Now I am selecting two shareholders, I am offering them shares. Now tell me, is this a rights issue or a private placement? See, I am identifying a new shareholder, I am allotting them, that's a private placement. But here in this example, I am selecting two shareholders, shareholder X, shareholder Y, that is existing shareholders. Now, if you understand, and I am giving offer to them, that is, I am issuing offer to them, saying, boss, I am issuing 5,000 shares, additional 5,000 shares to each of you. Now, is that a rights issue or is it a private placement? Somebody says private placement, somebody says rights issue. Now let's try to understand the basic difference between a rights issue as well as a private placement. When we talk about a rights issue means issue of shares to the existing shareholders in the existing ratio. Okay, issue of shares to the existing shareholders. So if you understand, let's suppose I want to raise another additional 10,000 shares. So I am giving 5,000 additional 5,000 offer to X, additional 5,000 offer to Y. This becomes what? Rights issue. Okay, or alternatively, now the company wants to raise same 10,000 shares. I am selecting a shareholder called as Z and offering him totally 10,000 shares. This becomes what? Private placement. Or alternatively, what am I doing? Let's suppose for X I am giving 7,000 and for Y I am giving 3,000. That becomes what? Private placement. So if you understand, issue of shares to the existing shareholders in the existing ratio becomes rights issue, and issue of shares to the selected group of persons is a private placement. At the same time, issue of shares to the existing shareholders in an indefinite proportion is a private placement. Now, if we try to, let's ignore all the law, everything. Let's try to understand which type of resolution that we have to pass. Okay, which type of resolution? We first have to understand, let's try to understand. We know only there are three types of resolutions. What are they? Special resolution, ordinary resolution, board resolution. Okay, of which two resolutions, special resolution, ordinary resolution happens in the general meeting. Okay, whereas in board meeting, board resolution. Now out of these three, okay, there are we have almost 7, of which we are discussing rights issue as well as versus private placement. Now let's try to understand with regard to the private placement or rights issue, which resolution do we have to pass? Yes, which resolution do we have to pass for the rights issue? Okay, we'll assume that to be ordinary resolution. Yes, how about a private placement? Special resolution. Okay, we'll just pack and try to understand. For example, you have your siblings at home, brother, sister. Okay, assume when you were kids, I am sure you are now matured enough, you don't fight for ice creams, but when you were kids, okay, your mom brings 2 ice creams or 1 box of ice cream, assume, okay, she brings and keep them in the fridge. Okay, when she brings them and keep them in the fridge, you went to school and your sibling was at home because for XYZ reasons. Now what did mom do? She has taken out the ice cream because sibling was crying for the ice cream. So what did she do? She has taken the ice cream and exactly divided into half and given his half portion to your brother. You have a problem with it? No. So if you understand, when she is giving exactly half portion to it, or your mom is taking out the ice cream and giving 50% to you, 50% to your brother, you have a problem with it? No, right? Again, so if you see, when the company, assume, when a company, as a board of director, I am a board of director, you two are the shareholders, and I am giving you the offer to the existing shareholders, that is you two, in the existing ratio. Do I have to ask your permission? Do I have to ask your permission? No. If you understand, if you keep me in the board of directors position and you are the shareholders, for rights issue, which resolution do we have to pass? They don't have to go to the shareholders. So which resolution is it? Board resolution. Getting it? Understanding it. So if you see, the shareholder right is not getting affected, the shareholder's right is not being infringed, or their right is not getting diluted, then what happens? Because boss, I am giving you the offer, you use it or not is upon you. Okay, so I as a board of director don't have to come to the shareholders for conducting the general meeting and passing the ordinary resolution or board resolution. So for rights issue, which resolution is it? For rights issue, if you see, it's a board resolution. Board resolution is conducted in which meeting? Board meeting. Right. Now let's try to understand again the same example. We'll continue with the same example. So the same ice cream which is in the box. Okay, your brother was at home. So what did she do? She has taken it out and given him 50%, but he was not listening to it. So she has given him 80% of your ice cream. What is it? What is your call? Are you okay with it? Are you okay with it? No. Agar you might say, mom, if you would have asked me, I would have given him 100%. ऐसा होता है, generally नहीं होता, but I'm just saying. So if you see, our right is being affected. So when your right is getting affected, you feel, boss, you should have asked me. Okay. Alternatively, Okay, a cousin of yours has come to your home. Okay, the same ice cream which is in the fridge. You didn't wanted your mom to even take it out, but your mom has taken it out. But what is the next thing? मैं जब परसों उसके घर गया था ना, he has not shared that ice cream with me, or he has not shared his toy with me, so I don't want to share. Or even if you want to share, you wanted you to be asked. Yes or no? So what does that mean? That means your right is getting affected. When your right is being affected, you wanted you to be consulted. The same way, if I am a board of director and you are the shareholder, I am want to issue shares to you in an indefinite proportion or to a new shareholder. Then what happens? You wanted me to ask it, right? When you want me to ask you, what is happening? A general meeting has to be conducted. Now when we conduct a general meeting, now we will have to understand whether it's an ordinary resolution or is it a special resolution. Yes or no? Whether it's an ordinary resolution or a special resolution. Now when we talk about, when we try to understand whether this is an ordinary resolution or a special resolution, understand whenever the shareholder's right is getting affected. Okay, wherever the shareholder's right is been getting affected or his right is diluted, the maximum times that we have to look at is the special resolution. Getting it? So if you understand, for private placement or alternatively called as preferential issue, which resolution do we have to pass? Special resolution. Which resolution do we have to pass? Special resolution. Getting it? So if you see, the law that we learn, the law that we have been learning is nothing new. It's just the same. Only thing is we will have to understand it. Right? Now, if you understand the moment when I say special, what we'll do is first I'll try to complete the rights issue, then we'll go into the what is it? The private placement. So now when we talk about the rights issue, which resolution do we have to pass? Board resolution. Board resolution is given, conducted when? In the board meeting, right? So when we talk about a board meeting, how do we conduct a board meeting? By sending a notice. So how many days before do I have to send a notice? How many days before board meeting? 7 days. Now the question is it a 7 days or 7 clear days? 7 days or 7 clear days? Now if you understand in law, in case if you have read your company law, like those who, as you have read your company law, it is for general meeting it is 21 clear days. For board meeting it is 7 days. Now the question is, now the question that I am asking is it 7 days or 7 clear days? Now understand both are right. It is 7 days and 7 clear days or 7 clear days. Sir, how is that possible? Understand, if you remember section 20, what does it talk about? Service of notice. What is service? How do you, if somebody wants to send a notice to the shareholders, what are the ways in which he can send? Speed post, registered post, courier, electronic mail or facsimile, which means hand delivery. Right? Now if you see speed post, how many days it will take certain time? Registered post as well as courier also will take certain time. So whenever you are sending a document through the speed post, registered post or courier, you need some time for the document to reach the opposite party. So in those cases it is 7 clear days. In case if at all if you are giving it through the electronic mode or through hand delivery, it is 7 days. Now who says this? The company law is not saying this. But whereas there is also something called as Secretarial Standard 1, which is a mandatory Secretarial Standard, which is just like you have auditing standards. The same way you have Secretarial Standard. There are 3 Secretarial Standards which are approved till date. Okay, which is compulsory for a company to follow. Of which the first one is talking about the board meetings, where it is clearly emphasizing it is 7 days in case if you are sending it through electronic mode, or it is in the other ways it is 7 clear days. Clear? So what do we have to do? I will have to send a notice. So how many days before? 7 or 7 clear days. Next, understand. Assume there are like 10 directors in a company. Okay. Now the issue is now we are conducting a board meeting, of which for example for the purpose of rights issue. Now out of the 10 we have sent a notice. Okay. Now assume, let's suppose there are 10 directors. Okay, I'll just park that for some time. So there are 10 directors. Now what happens is, out of these 10 directors, Let's suppose 4 directors were absent, 6 directors were present. Okay, out of the 6 directors, if 4 say yes and 2 say no, is the resolution passed or not passed? There are 10 directors in total. Generally, board resolution is what? Majority rule. Majority rule is what? More than half people would say yes. So, out of the 10 directors, 4 were absent, 6 were present. Out of this 6, 4 said yes, 2 said no. Is the resolution passed or not passed? It is very much passed. Why is it? Because those directors who were present and has participated in the voting were only counted. Right? Now, the question is, once this is passed, we have assumed that this is passed. But now the question is, meanwhile the other 4 directors who were absent, they are coming and claiming that we have not received the notice, the meeting, and they want to invalidate the meeting. There are chances such things will happen practically. So how to overcome this? So what we'll have to do is we'll have to take something called as acknowledgement. Acknowledgement for what? Acknowledgement for receipt of notice. Saying that, boss, I have received the notice. So the company will receive an acknowledgement. Once the company receives the acknowledgement on the date of meeting, first thing that what do? We take attendance. We take attendance. Attendance, why do we take it? To check the quorum. To check the quorum. And accordingly, what we will do? We appoint a chairman and conduct a board meeting and pass a board resolution. Yes? Now, after that, we will prepare meetings. That is all a different story, which I am not discussing right now. So, this is about what? Board resolution for what? Board resolution for issue of shares. Issue of shares. Issue of rights issue. Now, once I do this, what do? In the board resolution, I should also, this is for what? Issue of shares. In the board resolution also, I should also approve the letter of offer. I should also approve letter of offer, which I intend to distribute it to the shareholders. So once I prepare this letter of offer, I share this with the shareholders. Once I give this to the shareholders, what happens? The shareholders accept it. Now, we also have certain thing called as a letter of offer period. Letter of offer period is how much? I'm sure you might have read it. Offer period 15 days to 30 days. 15 days to 30 days. Now, letter of offer period is 15 days to 30 days. Okay. Now, I give the letter of offer. Once they receive the letter of offer, what is it? Next thing, they accept it within the due date and they send the share application money along with the share application form. Once I receive, assume, let's suppose on this letter of offer is applicable from 1st Jan to 20th Jan. Example. I am assuming I have given it for 20 days, 15 to 30 days. So I have given it for how many days? 20 days. Now when I have given it for 20 days, assume I have given it to 2 shareholders, shareholder X, shareholder Y. X has taken the shares on 4th. X has paid the money on 4th and Y has paid it on 10th. And both of them has agreed for 5,000 each. So both of them has paid 5,000. So accordingly, what has happened? Both of them have subscribed. Now the question is, can I close the offer or should I still keep the offer open? Because minimum offer period is how much? 15 to 30 days. So I have received the money within 10 days. So should I close the offer or should I wait till 20th? Perfect. So if you understand, the offer will be, we can close the offer because the purpose is already solved. If you remember again the Contract Act, it is not a standing offer. Because offer is given, the moment offer is accepted, the offer gets closed, right? So now the question is, I will have to allot shares, right? The allotment of shares shall be done within how many days? 60 days. So allotment of shares shall be done within 60 days from the receipt of share application money. Receipt of share application money. So this 50,000 whatever they have paid, assume on share application only they are paying complete amount. That is 5,000 into 10, same. Okay. Assume they have paid complete amount on the share application itself. So the allotment has to be done within how many days? 60 days. So if you can you just think and let me know what will be the due date for allotting the shares? Roughly, it need not be exact date. March? March 20th. Somebody says March 20th? March 1st, okay. 60 days from the closure of the offer. Okay. Now, if you see, we have seen 20th March. Okay. Now, if you see, I've got multiple answers, which is 60 days from the closure of the offer or 20th March. Assume. We'll assume that the average month has 30 days. I'm not including February, 28 days, 29 days. We'll assume the month has 30 days. Okay. Now, when did we close the offer? We have closed the offer as per your thing only. We have closed the offer on 10th. We have closed the offer on 10th because money has received. So offer is closed. So we have closed the offer. The offer gets closed on 10th. So if as per your answer, from 10th 60 days. From 10th 60 days, assume that comes to be 10th March. Right? In case if you are doing this, you will end up paying huge penalties. Sorry? Yes, because you are in compliance with this second person, that is 10th. But when we are talking about the first person, what is happening? For the first person, you have already crossed 60th day, that is almost 66th day. Because in case if you are not allotting within 60 days, you will end up paying huge penalty. Yes? So the offer has to be closed, the allotment has to be, in case if you want to allot for both of them in one allotment, then what should you do? You should take 4th as the first date. And from there you will have to consider 60 days. In case if you want to make it a separate thing, then what do? You will have to take it as for 4th. If you want to do separate allotment for 4th, you will have to take 60 days from there. From 10th, you will have to do separate thing. Clear? Now, I'll have to allot the shares because I have already received the money. I'll have to allot the shares. Now, if you understand, in exam, in case if we have to write, till here, we can say conduct a board meeting and pass a board resolution by duly complying with Secretarial Standard 1. So we need not write all this. We may write conduct a board meeting and pass a board resolution by duly complying with Secretarial Standard 1. So this is SS1. Once this is done, next thing is what we'll have to allot the shares. Understand something, for all these things, even including public issue, whenever I want to allot the shares or whatsoever things, allotment will always happen in the board meeting by way of board resolution. Clear? So I will have to conduct one more board meeting. This is board meeting 1. I will have to conduct one more board meeting. So one more board meeting is again board meeting, board resolution for what? Allotment of shares. So before this, I will have to do all things as per SS1. That is notice, acknowledgement, attendance, quorum, all these things has to be taken care. Once this is done, I have allotted shares. Once I have allotted shares, I will have to do 4 things. First, update register of members, because until unless you don't update the register of members, he is a shareholder but not a member. Because who is a shareholder? Whose name is entered in the, who has been allotted as shares is called as a shareholder. Okay, or whoever owns a shares is called as a shareholder. Who is a member? The moment his name is entered in the register of members, then only he is considered as a member, right? Then you will have to file return of allotment. Return of allotment, which form is it? Return of allotment in form PAS 3 within, okay? Return of allotment has to be filed. Yes. Then once this is done, we will have to issue share certificates. In case if the shares are, if the shares are in physical mode, you will have to issue the share certificates. In case if the shares are in demat form, then what do? You will have to intimate. Intimate the depository. Intimate the depository in case if the shares are in online mode. So if you see, it is, and understand something, this particular procedure, whatever is this procedure, this remains same for all this. Let it be rights issue, private placement, ESOP, whatsoever you talk, this thing remains same. Only difference what we understand is, it is because of the issue. As the name itself says, the difference is with regard to issue of shares, but not allotment. Allotment, everything remains same. Clear? Now, now if at all we are looking at the private placement. Okay, private placement, which resolution is it? Special resolution, yes. So here if you see, once this is done, now there is something that is coming into picture, it is called as special resolution, general meeting. So in general meeting only we will pass a special resolution. Yes. Again, for this what do we have to do? I will have to send notice. Notice before how many days? 21 days or 21 clear days? 21 days or 21 clear days? Because in the above thing I have told you, it is 7 days is right, 7 clear days is also right. How about here? It is 21 clear days. There is no 21 days because law is specifically mentioning that to be 21 clear days. So it will be 21 clear days only. Then again same thing, acknowledgement we may take it or we may not take it, because merely not sending a notice to a shareholder will not invalidate the meeting. Okay. Then attendance, quorum, chairman, and we will conduct the general meeting and pass a special resolution. Now before we pass a special resolution, we will have to keep certain things ready with us. So what are them? If you understand what do you mean by private placement? Issue of shares to the selected group of persons. So I will have to specifically select whom I am allotting. Okay, Mr. X, Mr. Y, Mr. Z, I will have to select, and I will have to maintain a data to whom I will have to issue. So prior to giving the offer itself, I will have to maintain a record of who are all the shareholders to whom I am allotting. So that record is maintained in which form? PS, record of proposed allottees. It is PS 5. PS 5. Then letter of offer. I will have to also get the letter of offer approved. Now if you understand, existing shareholders, in the rights issue, existing shareholders they know each and everything about the company, because unko annual report they are receiving the annual report, they know everything about the company. But when a new person is coming into the company, does he know anything about the company? No. So generally what should I do? I should give him every detail about the company. Yes. So in case if you have seen, when we are talking about the rights issue, I have not discussed much about the letter of offer, because a mere letter, writing a letter and giving it to the shareholder also will be considered as a letter of offer in rights issue. But when we talk about the private placement, there is a specific format. What is the format? PS 4, where it will give you the generally information, like general information about the company, name, address, location, all those things. Then financial information, whether the company has filed all the financials, and in case if it has filed, it will ask for the complete details about the financial statements, where you will have to disclose whether they have declared the dividend during last 5 years, everything about the last 5 years. And also it will you will also have to give the details regarding how many shares that you intend to give. Yes. And also you should obtain a valuation report. Valuation report from whom? Registered valuer. Previously, chart accountants were doing the valuation thing, but now it has been changed and the emphasis has given to a separate valuation, that is the registered valuer. Again, once you qualify this, you may have to write it and get qualified to give for 12 months. The same way, at the time of issue itself, I am passing a special resolution saying, boss, I would like to issue, let's suppose 2 crores of shares, of which again I can divide them into steps. First, for the first time, I want to raise only 50 lakhs. I give the offer. So offer letter is valid for how many days? 15 to 30 days. Getting it? So you can divide them into multiple tranches and accordingly segregate them. So once I give them letter of offer is valid for 15 to 30 days, and within 15 to 30 days, I will have to receive the money. Once I receive the money, I close the offer. Once I close the offer, what do? I again conduct the board meeting and allot the shares. Clear? Understanding the difference? But if you understand something, there are certain practical difficulties that you face. For example, if I am issuing shares to a person who is an outsider, foreigner. Let's suppose a company from US is investing in India. So I am allotting shares to them. Now the question is, from whom do I take the valuation report? I am issuing shares to a person who is residing in US or a company which is incorporated in US. That company is investing in India. Generally that is called as an FDI. Yes. So again the process all remains the same. But only thing is you will have to also comply with FDI procedure where the money is coming in, which we will also discuss eventually because you also have the concept relating to FDI. Okay. Now the question is, when a person from outside is coming and investing in India, you will have a practical problem, that is, from whom do I receive the valuation report? Okay. Now let's assume I have received a valuation report from a company secretary, assume, who is a registered valuer, or a cost accountant who is a registered valuer. Now the question is, I have received it and has submitted to RBI, got the approval, because they also has unique number which is given. Then what happens is, if you see, RBI accepts this, but the question is, when you look at from the income tax perspective, this is not accepted because they wanted it to be, RBI wanted it to be from the chartered accountant. Okay, but whereas company law is okay with the company secretary also being a registered valuer, but RBI specifically says I want it from the chartered accountant. Then what is that we will have to look at? That is, we will have to see that the valuation report that is obtained from a registered valuer, and that registered valuer is also a chartered accountant, so that you don't end up taking two valuation reports. Getting the difference? Yes. So this is more about the difference between a rights issue versus a private placement. Any questions? So this is more of a practical oriented, because you have already read the theoretical or provisional things in your interest. So I did not cover any provisions, much of the provisions. But if you understand again, you might have also read one more point saying the money has to come into a separate bank account. Yes. Why do you think so?
So that there will be an interference.
Yes.
Previous issue or from any statement.
I would not say previous issue, but what happens is, let's suppose I have a bank account in which my revenues are coming in as well as the share application money is coming in.
There would be a cluster of.
Yes. So they both get added up, and there is also chance that if I have this account right now with me, I may end up utilizing the amount. Understand, I cannot utilize the amount till which date? Exactly. If you think practically, till the shares are not allotted, those money do not belong to me, because if I am not allotting within 60 days, I will have to refund within 15 days along with interest. In case if I am not doing it, that is considered as what? Deposit, where I will end up paying huge penalties. So if you understand, I will have to allot them only I can utilize them only after the allotment of shares. Now this is how things work. But again, why the money has to come into separate bank account, that is one thing, and this is taken from the public issues. In public issue, what happens? The money will come into an escrow account. There is a separate account which has been kept, which is called an escrow account, where the money will come and get parked, and the company will not be able to utilize it. Okay, once allotment, the money gets transferred to your regular account. So the same way, this particular provision is taken from there, so that you don't mix up your regular accounts with the share application money account. Clear? So that is more about the rights issue and private placement. Any questions? Yes? So this is more about rights issue and private placement. In case if you have any questions, I can take it up. Acknowledgement. See, there are chances for, if the company is not receiving the acknowledgement, there is always, you are giving a scope to a director to file a case against you to invalidate the meeting. See, understand, if you are giving why do you want to give a chance? Because when the law is specifically saying, boss, do this so that you don't end up, still if you don't want to do it, there is a chance. So do not give them a chance so that you don't end up, getting into trouble. Clear? Because what happens is, we have seen cases where, let's suppose there are 5 directors. Out of these 5 directors, 3 directors will be on one side, 2 directors will be on the other side. So this one of the directors send notice to all the five directors. What happens is, those 2 directors do not come to the meeting. These 3 directors will come, because the reason why those 2 directors will not attend the meeting is, they know even if they attend, they will lose. That's the reason they don't turn up. So these 3 directors present in the meeting, conduct the meeting and pass a board resolution for XYZ reasons. Okay. Later on, these 2 directors file a complaint saying that, boss, this meeting is invalid. They have doing it. There is a chance for mismanagement operation cases also coming into picture. So you don't give them a scope. Understand? In case if they are not giving an acknowledgement, you have registered post acknowledgement due. Just like if you have seen in court summons, what happens when a court sends a summons, you will receive them or you will receive it. The moment you receive it, one more post will go to the court saying what? Yes, boss, they have received it. So understand, that means what? The notice has been given to you. That means you have summoned. Summoned means what? You have been called to court to present yourself. So if you are not coming to the court, you are going against the court. Again, that's a problem. The same way, when there is a concept called as registered post acknowledgement due. What does that mean? The moment you receive it, the acknowledgement goes to the company again, so that you are on a safer side. Generally, for the general meetings, we do this. Because where the number of shareholders are more, we don't end up taking acknowledgements from the shareholders. So what do? Even it is little costlier, but still we do it so that things are, the company is on a safer side. Yes? Yeah. Any other questions? So if no other questions, we'll stop this session for the day. Yes? Thank you one and all. Signing off, Vikram.